Very interesting.
It happens, but it's a little bit vague on that, especially because you get a special master.
Right.
Hi. Hello. Hi, good evening. Hi, everyone. Uh, my name's Neil Devins. I am a professor at the law school here. I'm director of the Institute of Bill of Rights Law as well. And on behalf of the law school and the Institute, welcome to the preview. So this is our 29th year, and like other previews, we begin with the moot court. And as you all know, the preview is an opportunity to talk about the Supreme Court and the term ahead, and we bring together journalists, Supreme Court advocates, judges, law professors, and our moot court reflects the diversity that is the preview. Everybody on the moot court will be, from those groups, an advocate, journalists, judges, and we are really delighted that you're here. So today's moot court comes from a case called Pena Rodriguez v. Colorado, and the issue is the admissibility of evidence of race bias in jury deliberations. The state of Colorado has a rule which protects the sanctity of the jury and jury deliberations and does not allow for evidence to be introduced of what the jurors are talking about. Pena Rodriguez is challenging this rule under the Sixth Amendment and the right to fair trial. He claims that discussions of race bias by the jurors violate his right to fair trial and that the court needs to take this into account. So here's what happened. In 2010, Miguel Pena Rodriguez was tried for sexual assault. During the deliberations, one of the jurors said he was guilty, quote, because he's a Mexican and Mexican men take whatever they want. And the same juror also said that 9 times out of 10, Mexican men were guilty of being aggressive towards women and young girls. So Pena Rodriguez was found guilty of 2 misdemeanors and sentenced to 2 years of probation. He then challenged his conviction on the basis of this race bias in the jury deliberation. In May 2015, the Colorado Supreme Court upheld the conviction by a vote of 4-3. The 4 in the majority emphasized the sanctity of jury deliberations. The 3 in the dissent said that, and I quote, that however important the sanctity of deliberations are, they cannot trump a defendant's opportunity to vindicate his fundamental constitutional right to an impartial jury untainted by the influence of racial bias. In terms of Supreme Court precedent, the most recent case is a 2014 case where the court unanimously held that statements made during deliberations cannot be considered, even if they speak to falsehoods told by potential jurors during the process of jury selection. So a potential juror misled the attorneys, and that misstatement was not something that could be used as evidence to question the verdict later. But the court noted in a footnote that there might be cases that are so extreme, that there might be cases of jurist bias so extreme that the jury trial right has been abridged. So Pena Rodriguez is now claiming that this case of racial discrimination, racial bias in jury deliberations is one of these instances of an extreme case that the court should rule violates the right to fair trial. And in November 2015, he filed a cert petition. On April 4th, 2016, certiorari was granted, and on October 11th, 2016, the court will hear oral arguments in the case. Our advocates tonight are David Strauss from the University of Chicago Law School. He's representing the petitioner, and Chris Landau from the Kirkland and Ellis Law Firm representing the respondent. So thank you, Chris. Thank you, David. We appreciate your efforts. And with that bit of background, we will start our moot court.
All rise. The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Warn me not to bang
The court will now hear arguments in number 15606, Pena Rodriguez versus Colorado. Professor Strauss, before I start, I understand you're going to reserve 5 minutes for rebuttal.
Yes, that's right.
Proceed, please.
Thank you, Madam Chief Justice, and may it please the court. Statements that petty jurors make in the jury room can already become public in many ways. Even the strictest versions of Rule 606B, like Colorado's, allow exceptions for extraneous prejudicial information and outside influences. Juror statements can be used to challenge the impartiality of the jury if they come to light before the verdict is rendered. After the verdict, a juror's statements can be used against the juror, him or herself, in a proceeding, for example, if the juror is accused of having lied in voir dire. And almost everywhere, the jurors are free to describe and publicize the jury's deliberations or their version of the jury's deliberations. The question here is whether statements offered to a trial judge to show that the verdict was infected by racial bias should be added to that list. Now, there's no dispute that a defendant convicted by a biased jury has been deprived of his rights under the Sixth Amendment. The only question is whether certain evidence...
Discrimination in this case had been on the basis of gender. The discriminatory comments were based on gender, and clearly demonstrating a bias and a decision driven by gender rather than race. What would your position be?
If they were on the basis of gender. We don't think that the court's ruling in our favor in this case would commit it to extending the
But do
holding
you think
to
it's
gender.
really possible to draw a line between race and everything else that could be shown after the fact to be a bias? Isn't this going to be a slippery slope?
I think the court, as Justice Smith, the court has drawn that line in a number of cases, actually. The clearest example that I can think of is Rose against Mitchell, where the court held that a defendant who had been convicted by a fair jury after a fair trial nonetheless could have his conviction set aside on habeas corpus because racial discrimination infected the grand jury proceedings. That was a decision in 1979. The court has never extended that beyond race, and the court explained in that opinion just how
Has
corrosive...
it been asked to extend it beyond race?
I don't know if
Have
it
we
has...
been asked?
I don't know if it has, Justice Millett, but...
Given Batson versus Kentucky, which we felt had to be extended to gender, I'm just wondering if even constitutionally we could say just race but not gender or religion, if it had been, for example, anti-Muslim comments.
I wouldn't say that the court needs to foreclose that extension, but I also don't think the court is committed to it. I mean, your example
Isn't
of...
the constitutional violation, as far as the defendant goes, the same? There's the same degree of impartiality, the same degree of bias, the same degree of unfairness, the same violation of the Sixth Amendment, whatever the motive?
Well, two answers, Justice Smith. As far as the defendant goes, it is true that in this case, a violation of the defendant's Sixth Amendment rights looks like other violations of a defendant's Sixth Amendment rights. But one thing the court's decisions in the race area in particular have emphasized is that racial bias in the criminal justice system has effects that go beyond the particular trial. And that, I think, is the significance of the case I mentioned before, Rose against Mitchell, where the defendant was, after all...
Not so with religious discrimination, given we've had plenty of trouble with religious discrimination in this country as well.
The court's decisions, Justice Millett, pretty consistently have emphasized the corrosive effects of race, even beyond those of religion or the other
And gender.
categories, or gender. And
I think Rose against Mitchell is still good law in the post-EDPA world of what's happened to habeas. Would today's court even bother to apply it?
well, the habeas piece of it, I think, Justice Greenhouse would pose a different question under EDPA, but on the merits, the question whether bias in grand jury proceedings justifies overturning a guilty verdict rendered after a fair trial, I don't see any reason to doubt that's
Nothing in the Sixth Amendment talks about race as having a distinct status in determining whether you've had a fair and impartial jury. And so I'm trying to figure out on what basis we could decide that race and, from your brief, ethnicity are in, but other denials, equally clear and blatant denials based on discrimination that the Constitution protects against, would not deprive someone just as much of a fair and impartial jury. And if we go down that path, we start really having a lot of challenges given our precedent.
Well, I'm not sure that path would be a terrible path to go down, Justice Millett, and I don't want to suggest that it would be, but just to your point, I think there is a considerable basis for the court to say, at least now, it is race and only race. You mentioned Batson and its extension to gender. Batson was decided in '86, JEB was decided in '94. The court did not treat the outcome in the gender case as a foregone conclusion after it decided Batson. There were a series of cases in the 1970s where the court engaged the question whether in voir dire the question had to be asked about racial bias. There's no similar set of cases having to do with gender or religion or anything else. So I think there is, and Rose against
But the
Mitchell's
whole point of
Medicine-
JEB was that you have the same, that in protecting your right to a fair and impartial jury, we have to make sure that there are not the use of peremptory challenges in a way that injects gender discrimination into the jury decision-making process or the trial process. So I don't know how after JEB, given that we made that equation there, we would have any reasoned basis to say that race counts for these purposes, for looking at deliberations, but not gender.
I think my point about JEB, of course, has been decided the way it was decided. My point was the court apparently didn't consider that question totally
No, I've got
foreclosed
it.
after
We took some
Batson.
time, but there we were, right? And so the question is, can you articulate for me what the reasoned basis would be for confining this to race and ethnicity?
I think the reason basis would be, Justice Millett, that in case after case, really, the court has emphasized the particularly corrosive effects of racial discrimination in the criminal justice process in particular.
And so gender discrimination is not corrosive in the...
Gender discrimination undoubtedly is corrosive, but you do not have a
This
string.
discrimination would be pretty corrosive.
Religious
We don't like
discrimination-
Muslims, we don't like Jehovah's Witnesses.
I am certainly not going to suggest those
No,
are acceptable.
that's the point, is it just as corrosive, is it not?
I think historically race has a special status.
Can I ask
What
you-
if,
Go
I'm
ahead.
sorry, what if a juror in deliberation says, I believe that the defendant is not guilty, but I'm the only one, so I'm going to go ahead for the sake of consensus and vote guilty? Isn't the due process consideration there as important as the equal protection consideration you present in this case?
Justice Chemerinsky, my answer is going to be a variation of my answers to Justice Millett and others who've asked about race. I think that the effect that while in each of these cases, including cases in which the court has refused to read an exception to Rule 606B or refused to read it narrowly, in each of these cases, you do have injustice to a particular defendant. What's different about race, and the court has said this from its earlier decision involving race discrimination in juries in Strouder against West Virginia, right up to the present day, the court has said this, racial discrimination has broader effects on society. It affects
In
the status
wrongful
of a group in
convictions?
society.
I mean, isn't the concern about wrongful convictions just as great as the concern about race discrimination?
There is, of course, a generalized concern about the fairness of the jury process, but the idea that in any case, but the idea that people are being convicted because of their race, and this is not something the court has shied away from saying, that is particularly
Can
bad.
I ask
That is
you a
particularly
question about
damaging.
that, Counselor? The assumption seems to be that the conviction here occurred because of the racism of this one jury. Given the requirement of unanimity and the fact that clearly some of these jurors who voted to convict were appalled by the statements that this juror made, why should we bend over backward to act as if the conviction here was obtained as a result of racial discrimination on the part of one person when it clearly was not shared by the rest of the jury?
Justice Smith, we're not asking you to do that. The only question is whether this evidence is to be excluded from a hearing before the judge, at which arguments of the kind you just suggested could be presented and might easily be persuasive.
So you would concede that unless that he can show in that hearing that the racism was the reason why the conviction occurred, he doesn't have a remedy?
Well, I think he has to show something. He has to show a substantive. The cases in jurisdictions that allow this sort of evidence, and there are a substantial number of them, those jurisdictions have a standard that the defendant has to show a substantial probability that that racism affected the verdict. And I think that would be the question before the trial.
What
judge.
does it mean affected the verdict?
that the verdict would have been otherwise had it not been for racism.
Doesn't
A
that seem to
substantial
be
probability.
essentially impossible here on the undisputed facts? I mean, when you have jurors who were appalled at the racism and turned him in, basically?
Well, it's hard to say, Justice Smith, and I think that's a question that the trial judge is in a uniquely good position to resolve. The trial judge, having seen the trial, having a sense of the evidence, probably having a sense of the jurors from the voir dire, from seeing them at trial, from his communications with the jury, probably has a sense of whether this comment had an effect on the outcome of the jury, and that's what we're
Didn't the
asking for.
jury acquit him of the most serious charge also?
It acquitted him of the most serious charge, but this jury, there were issues with this jury. The jury initially came back and said it was hung. The judge gave them an Allen charge, sent them back, brought them back again, and they rendered the verdict. And the judge actually said, something like, "I heard a lot of noise coming out of the jury room. I doubt you all are ever going to be able to agree on a verdict on the most serious charge," and dismissed them. So this wasn't an open and shut case. As far as we can tell, of course, this wasn't an open and shut case. But as I say, these really, our point is really only that this question ought to be resolved by the trial judge, and the trial judge ought to have before him evidence that is singularly useful in resolving this question, which is the statements this
case,
person made.
the discrimination was targeted directly to the defendant and also his witness. If the discriminatory comments were just to about witnesses, but not about the defendant, would your position be the same?
There, I think the question would be whether those discriminatory comments about witnesses somehow implicated the defendant. But if they did not, if it were just the witnesses, I think our position would not be the same.
Can you explain to me what you mean by implicating the defendant? I mean, if it's the prosecution's witnesses, it's okay to have this corrosive racism in the jury room, but if it's a defense witnesses, we can't?
Well, the right belongs to the defendant. It is the defendant's Sixth Amendment right to an impartial jury. And the question would be, was that right affected by the comments? And if statements about a witness did affect that right, then yes, we would say that.
So racism in his favor is not something we need to worry about protecting against.
Well, the prosecution does not have a Sixth Amendment right to an impartial jury. I mean, there might be there are various other mechanisms the court could use, but that does not present a constitutional problem.
If both sides had witnesses of a minority group, what would happen then?
I think that's an example of the sort of thing that a trial judge would be in a position to
No, I'm just trying to
decide.
understand the rule that you want. Is the rule limited to racism directed at the defendant, or is it racism directed at any aspect, either the defendant or any aspect of the defendant's presentation of his case?
I would say, Justice Millett, it is racism that undermines the defendant's right to an impartial jury under the Sixth Amendment.
And what if they were racist towards the judge?
I think the answer would be the same. The defendant would have to show that not just that this was ugly conduct, but that his right to an impartial jury was affected.
So to some extent, racism can be in the eye of the beholder. The facts in this case was pretty blatant, but have a gray area. And I suppose the state's concern is that jurors will be chilled in their responses to testimony if they feel that any negative remark they might make in a racially charged case, for instance, could be ascribed to racism that they don't necessarily possess, but would open up the jury room. Do you have a response to that?
Justice Greenhouse, I think the argument about chilling deliberations, I think there's just less to it than meets the eye. I mean, as I said, there are many, many ways in which comments can become public, some of them with no assurance of reliability at all, as, for example, when another juror says what someone said in the jury room. And the idea that given all those circumstances, this marginal change, which after all doesn't affect the juror personally, it affects the verdict, but doesn't affect the juror personally, this marginal change will tip the balance, and this alone will chill a juror from saying things he or she otherwise would have said. I just doesn't seem realistic to me.
What questions did you ask during jury selection to make sure you didn't get a prejudiced juror?
The trial counsel did not ask questions in voir dire.
None at all.
Justice Barnes, I asked a general question about prejudice, but you raise an important point. One of the arguments the state makes is that voir dire provides the way to solve this problem. I actually think that is quite mistaken for the following reason. The instances in which you're actually going to see prejudice in jury deliberations, I think, are likely to be very few. But if we have a regime in which the only way to deal with that problem is aggressive voir dire, then you'll see questions about race and race prejudice brought up repeatedly in voir dire by defense counsels, either very sophisticated or looking to try to create a grounds for reversal. We'll push the boundaries of asking questions in voir dire. I think that's not a desirable result in its own, and it's also just not a very good thing for the very first stage of a criminal trial to focus on race, when most of the time that's not going to be necessary. So I think the idea that these issues can be shifted to voir dire is exactly backward. I think that would be a serious misstep.
But if we're going to be hearing these cases twice, if they're just going to come back in a form of a rehearing and we're going to have to go through it all the way again, why wouldn't it be better at least to deal with it all in voir dire?
Well, I don't think these cases are going to come up that often, Justice Wolf. I mean, we actually have evidence about this. There are a substantial number of jurisdictions. We disagree with the other side about how many, but it's a substantial number of jurisdictions, including apparently 2 federal circuits, the First Circuit quite unequivocally, in an opinion written, by the way, by a respected district judge, that allow these kinds of challenges. And we just haven't seen problems. You would think if there were a problem, we would see, for example, opinions written by trial judges saying, boy, this rule is really creating problems. This is a terrible rule. It's messing up trials. I constantly have defense counsel soliciting statements from jurors. We just don't see that. We just don't see that. I think this is not a problem likely to arise very often. And I think when it does, trial judges have a way of handling
You
it.
seem to assume in your prior answer that people don't raise the question of race in voir dire frequently. In my experience, people get asked all the time in the jury voir dire process. Is there anything about race, gender, orientation, anything about this defendant, or do you know him personally, or anything else that would prevent you from being impartial here? And I don't think that's a problem when those kinds of questions get asked, and it seems to me that gives a predicate for a remedy that you guys don't have in this case.
Well, the 2 answers, Justice Smith. I mean, I don't think if trial counsel makes a strategic decision that I am not going to raise the question of race because it just might heighten the problem and alert the potential jurors to the existence of race in the case or insult the potential jurors, that ought to be within the realm of acceptable strategic judgment. But beyond that, I don't doubt that in many cases, questions of this kind are asked. But should the court say, this is the solution to this problem, and the federal government suggests this in its brief. It has a variety of very subtle, sophisticated ways a prospective juror can be questioned to try to get at racial bias. If that is proposed as a solution to this, that defense counsel should engage in these subtle forms of interrogation, I think that's not a good result, partly because of the reasons I said, that it makes race front and center, and partly because it'll open up new grounds for these cases to be challenged, not in a context where we actually have a statement.
But why isn't that better than opening the door into juror deliberations further? Why isn't that a better course of action?
Justice Millett, as I said, I think the door is already open.
But what about another step in the process? Was there any way these jurors who did then talk about what kind of comments HC had made could have come forward sooner, pre-verdict? They heard him earlier. Do you know anything about any way that they could have come forward, again, before they had a verdict, if they were so disturbed?
Well, Madam Chief Justice, they could have come to the judge before. Had they come to the judge before, there's no question that the proceedings could have proceeded with HC's statement being considered, and it would have been considered on the question of whether the impartiality of the jury was already compromised. But to me, that just suggests the oddity of saying once the verdict is rendered, then the curtain comes down, when any chilling effect, any idea that jurors could potentially be acting out of animus toward their fellow jurors, that's going to be present in both
But that
cases.
answer, go ahead. Okay, so that answer applies to allowing us to examine all forms of bias, including the bias we had a couple years ago in that, what's the Werger case?
Yeah.
Werger case. I mean, that was arguments, if they were going to work, would have worked then, not now.
Justice Blatt, I understand that, but what I'm saying is if the court in this case, I mean, as we all know, has to strike a balance between getting at racial discrimination in a critical part of the criminal justice process and protecting the integrity of the jury. And to the extent, if that's the right term for it, the integrity of the jury has already been compromised, that shifts the balance.
No, but then, I'm sorry, you go ahead.
I'm sorry, isn't there an enormous difference before the proceedings are final and after the proceedings are final? Before the proceedings are final, there's the possibility of excusing this juror proceeding with an alternate, assuming there is one. There's the possibility of the judge individually questioning the jurors to see if they were tainted. Once the proceedings are done, then I'm still troubled by what happens now. Your answer earlier was, well, it goes back to the trial judge to decide. But what does the trial judge do? Is it automatic that this was said, that the verdict has to be overturned?
Oh, it's certainly not automatic. I mean, the trial judge has a hearing. It is actually, Justice Chemerinsky, like a hearing that you see judges already have when they are dealing with the exceptions to 606B. So let me give you an example. If this juror, instead of saying, I've worked in law enforcement and let me tell you this is how these people behave, if he had said, you know, I have a buddy and I was talking about this case with him, and he works in law enforcement. And he said, you know, I've seen things just like that, and that's how they behave. And he said that in the jury room, that I think it's not an open and shut question, but there'd be at least a very strong argument that is an improper, prejudicial outside influence, and the judge would have to have a hearing. And did that influence the jury? And that would be the kind of hearing we contemplate.
But haven't you said race is different from everything else? Doesn't that then mean if race is different, once a racist comment is made, it really means the verdict has to be overturned?
We don't take that position, Justice Chemerinsky, partly for reasons that have come up in argument, that exactly what constitutes a racist comment is difficult to say, how it's received by the jury. Maybe the jury repels it, maybe the jury treats it as a joke or as a stray remark, and all of those things are in play. If I may, I'd like to reserve the balance of my time.
Thank you, counsel. Mr. Landau?
Thank you, Madam Chief Justice, and may it please the court. The question in this case isn't whether a juror's racial bias, or for that matter, any other type of bias, violates the Sixth Amendment right to an impartial jury trial. We can all agree that it does, and this court can and should reaffirm that fundamental principle. Rather, the only question here is whether the Sixth Amendment requires the admission of a particular type of evidence to prove a juror's racial bias. Post-verdict affidavits from other jurors about what was said during juror deliberations. The answer to that question is no. For centuries, the right to trial by an impartial jury has coexisted with the rule that such post-verdict juror affidavits about jury deliberations are not admissible to impeach a jury verdict. That rule is reflected in Federal Rule of Evidence 606B, which was drafted by this court and approved by Congress, as well as analogous rules in virtually every state, including Colorado. Petitioner now invites this court to declare all of those rules unconstitutional insofar as racial bias is alleged. Nothing in the Sixth Amendment requires such a holding. By definition, a biased juror is the antithesis of an impartial juror. No one is defending biased jurors. But that doesn't mean that all forms of evidence are admissible to address juror bias. Just as any and all forms of evidence aren't admissible in a trial involving racial discrimination to try to prove such discrimination.
Your position would be the same if evidence like this had come up in the sentencing stage of a death sentence and the racist statements were targeted to why the person should be executed?
Well, Your Honor, this court has certainly said there are Eighth Amendment considerations of death is different. So, right now we
Do
are
they
arguing.
apply to the Sixth Amendment context or not?
Well, again, we have here a Sixth Amendment case. Whether or not those Eighth Amendment considerations require a different rule.
I think it would be a Sixth Amendment consideration in a death penalty case. I'm not sure it would be
I
an
don't think-
Eighth Amendment problem.
I guess, right, well, certainly to the extent that it's not an Eighth Amendment
Excuse me, your
problem.
argument is, golly gee, we sure would be opposed to that. That's a really bad thing, but this is just all about the evidence that we allow in to prove bias. You'd make the arguments you're making now would apply just as much there, would they not?
Unless, again, the Eighth Amendment has been used by this court repeatedly on the justification that death is different and there are different rules for death penalty sentencing than there are for other forms of proceedings. Certainly, I think the key point here, and I think opposing counsel, my friend, started out really by saying that, the court, in a sense, it would not be a terrible path to go down a path that says any kind of bias is insidious, whether it's race, as this case is alleged to be, or gender. The 14th Amendment certainly does draw certain kinds of distinctions among different kinds of discrimination. The 6th Amendment does not. The 6th Amendment, which is the only one presented in the question presented, gives you the right to trial by an impartial jury. As this court held just 2 years ago in the Warger case unanimously, evidence of bias or allegations of bias are not sufficient. They're not an exception
So
But
do
to the
counsel,
rule.
in that case, we also unanimously raised the possibility that we might see someday a case just like this, where racial bias was so extensive that we might believe it's time for an exception.
Oh, Your Honor, with all respect, you did not say racial bias is so extreme. You said there may be examples of bias so extreme. That is talking about the degree of bias, not the type of bias. This court has
But
never
couldn't
suggested.
this be a degree of bias so extreme?
Well,
Even though it occurs in the racial context,
Well,
which would give us even more concern?
certainly the rule that is being advocated here by petitioner is not a degree. They're not asking you to reverse on the ground that there was some degree of bias. They're asking you to announce a categorical rule that race is different. I think they said that very clearly in the first paragraph of their reply brief. The line they are drawing has nothing to do with degree. It is race versus everything else. That line is alien not only to the 6th Amendment, but frankly to the 14th Amendment as well,
Then
even though
what
this is
would
not a
the
14th Amendment
be-
case.
Let me just think for a minute. If we were looking at a case, what kind of case would be set to the degree that you think we meant in that statement that nobody dissented from? What kind of evidence would we
Well-
see? What kind of comments would we be getting from the jury?
If a juror impeded the deliberations of the jury by making such extremely biased comments, perhaps. Well, one thing just to be clear, this court did not say in that footnote that that was an exception. This court says we have no occasion to consider whether or not there is.
We were
such-
concerned enough to raise it. That's why I'm just
That's right.
asking
But,
now.
but I guess
I don't know
what
why the example you just gave didn't apply to this case.
well,
These are just rabidly bad comments.
and-
Not,
and
and 4 or
again,
5 of them.
we
Taking out the witness too.
we agree.
In a closely hung jury that was on the verge of being hung.
Well, Your Honor, again, we agree, and this court in Wergers actually said that where that footnote comes off of, I think, is really that the passage couldn't put the point better. It says, a party's right to an impartial jury remains protected despite Rule 606B's removal of one means of ensuring that jurors are unbiased. Even if jurors lie during voir dire in a way that conceals bias, juror impartiality is adequately assured by the party's ability to bring the court's attention any evidence of bias before the verdict is rendered and to employ non-juror evidence after the verdict.
Mr. Landau, none of the 4 ways of finding out this gentleman's bias seem to have worked. And at the beginning, you gave a ringing defense of the 6th Amendment and you said that the defendant deserved a fair trial. Apparently, none of the other 4 ways of finding out whether there was a biased juror worked. So in that case, wouldn't we revert to not abiding by 606?
Well, Your Honor, we don't know if they work because all we know right now is that there's an affidavit by another juror disclosing what happened in juror deliberations. And counsel then went with that affidavit to the court and said, I would like to admit this affidavit, notwithstanding the rule. I'd like a 6th Amendment exception to the rule. That counsel could easily have, there's no evidence that counsel went on social media to try to find if that juror has said anything else, if that counsel is free to use that contact from a juror as a launching pad into these other mechanisms. Again, the only question here is there any reason that the 6th Amendment requires an exception to this rule of Colorado law and implicitly to this court's Rule 606B?
What if in the midst of the jury deliberations, a juror passed a note to the judge saying, one of the jurors has said the following racist comment, identical to this case? What should the judge have done under those circumstances?
So, Your Honor, just to clarify your question, you're talking still pre-verdict?
I'm sorry, that's right. During the jury deliberations.
Then it seems to me it's entirely appropriate for the judge to stop everything and because it's a very serious allegation. We do not diminish that in any way. I think the judge should talk to that juror, talk to the other jurors to make sure what happened. If in fact, there might have to be a mistrial. It may be, but
I don't understand in terms of the sanctity of jury deliberations. What's the difference? Why is there a magical difference once the proceedings are final as before, if what we're focusing on is the sanctity of the jury's deliberations?
I think, Your Honor, again, this goes, you yourself made the point earlier, Your Honor, that there is a strong interest in finality after the jurors' deliberations are done. And in fact, that is reflected, we're not making this up out of thin air. I mean, this is reflected in centuries of jurisprudence that there are all these various mechanisms. And in fact, I think counsel...
No, but I just want to be clear now, because a lot of your brief and argument had been about the sanctity of juror deliberations, and we just have to hold the line. But now it sounds like you're saying, no, there's actually no sanctity as long as it's a minute before the verdict is read as opposed to a minute after. And this is all about finality.
Well,
It's just
not all- I mean,
finality is the interest then. But it has to be. That really has to be it, because we don't protect the sanctity against race discrimination or all other kinds of bias before a verdict.
Your Honor, I think there's a constellation of values. Finality is a very important value. So is generally the black box of jury deliberations. It is true that the black box is not an entirely black box until the moment of a jury verdict. But that only underscores the point that
But there's also other exceptions to that black box. I mean, that's what I'm having
and
trouble
that's-
struggle with. If it's prejudicial extraneous information,
right.
Then we blow the doors open. But
Right.
why is that? So if someone had the example that your friend gave, so if someone had said, "Oh, I got this information from my buddy who's an expert in law enforcement," and then said these things,
Right.
what would happen in that situation?
Well, that is a recognized exception. This court promulgated Rule 606B and has that as one of the exceptions. That is also an exception to the Colorado rule. What we have here is the rules of
I
evidence.
get that we don't fit in that exception. The question
But there's
is
a reason for that
constitutional
exception. In other words, there's a variety of reasons for that exception. I mean, certainly the black box of the jury is an important consideration. It's not a trumping consideration in all circumstances. But when you combine that with finality, the long-standing view of our legal system, and again, Colorado is not an
But
outlier
black box
here.
and finality, when it's I heard from my buddy, the expert on law enforcement, you have those exact
Right,
same
but
things. So
that-
why doesn't the Constitution say, look, we've got a balance here. You either care a lot about it or you don't. And the fact that
Well-
you've got this Swiss cheese exceptions here means, you know what? We better let race in.
No, but Your Honor, again, these are not Swiss cheese exceptions. There's a very fundamental difference between outside external influences on the jury and the jury deliberation, these jury's internal deliberations. Just
In
What
that
is the
hypothetical, there's not any meaningful distinction, is there? I mean, it's basically the same statements attributed to a law enforcement officer. It just happens to be a third person instead of the first person. It seems like it'd probably be more persuasive coming from the guy himself about his own experience, which for some reason didn't get revealed either. I don't know how you can, as a constitutional matter, draw that distinction.
Well, but again, the question is, does the Constitution require overturning the policy judgment? We're not drawing the constitutional distinction.
But you agree it would be unconstitutional not to let the other evidence come in about the extraneous statement? Don't you think that the Sixth Amendment permits the state to say, we're not going to listen to that either?
I don't know that the exceptions to 606B
Well, what's your
are
view?
constitutionally, that issue hasn't been briefed.
That's
Those are
not-
not,
that's
but no, but those are not, put it this way, Your Honor, those exceptions do not have a historical pedigree. I think it's hard to say that something is unconstitutional when it's been the law in our legal system for 200
That's worse
years.
for you than if we've just made a policy choice that we care more about extraneous facts than we do about overt race discrimination. Then that seems to me that in this balancing, you're going to lose.
I think, Your Honor, the point is we care about overt race discrimination, but we also care about the finality of jury verdicts and the way that this is all that is being at issue here is what is the appropriate evidence to look at to try to prove this. Again, nobody is saying that the right to an impartial jury is not violated by bias, just as the issue came up in the Warger case 2 years ago. One of the jurors in that case.
But you said death is different, and I think there's a good reason to ask, is not race different? Race and ethnicity, given the history of how racism has many times, in many instances, contaminated the judicial process.
Your Honor, again, I think that is a 14th Amendment question, not a 6th Amendment question. The question of juror bias, if you are conceding that there are statements of juror bias, The question whether that violates the right to an impartial jury is the same
No, the
regardless.
question is whether the 14th Amendment concerns or equal protection concerns can even inform our analysis of a state's decision which exceptions to have to this so-called sacrosanct black box of jury deliberations.
Could I just add to Justice Millett's question? Where the Sixth and the 14th Amendment converge, it seems to me, is in the need for the public to have confidence in the criminal justice system, in its fairness, and
Sure.
its ability to mete out justice
Sure.
fairly. So, given that, what's the downside to accepting the petitioner's position?
Well,
What's the problem that you're arguing against?
I don't think there is any way to contain this to certain forms of bias. I mean, race is terrible. I think some of the questioning earlier said bias on the basis of gender or sex is terrible. On the basis of religion is terrible. Once you go down this
If we could confine
road,
it to race, leave that work to us. If we could, I'm just hypothetically, if we could confine it to race, then what is your answer to Justice Greenhouse's question? What are you fighting against then?
I don't think the Sixth Amendment, this case, just to be clear, the question presented is very clear. The alleged violation here is of the Sixth Amendment. The Sixth Amendment.
The state, there's actually it's a violation of the 14th Amendment that incorporates
Well, yeah,
the Sixth
but I mean,
Amendment.
but they're not alleging that it's a due process violation. Fair enough that it goes through the 14th Amendment, but it's not.
Through the Due Process Clause, no less.
Well, yes, but it's still rooted in the Sixth Amendment. This is a Sixth Amendment case, and so the principles that are being requested, the ruling that is being requested here is a ruling based on the Sixth Amendment, because the Sixth Amendment does not. It's about preserving the right to trial by impartial jury. That right, if it is not imperiled,
the biggest
only
problem
by
this country has had historically with impartiality in juries has probably been race.
Well, Your Honor, but there's a lot. I am in no way diminishing that, but there are lots of other. And bias is the problem. The Sixth Amendment is directed against
if we
bias.
can confine it to race, if we believe we can do that, given the history, given that these are afterward, the 14th Amendment is after all a post-Civil War amendment. If we feel like we can do it, can you still tell us what it is you're so worried about?
Frankly, then that raises other questions as to what is even a racist comment. Again, I will concede this case. It's one of these cases. Bad facts make bad law. I think you have to be very careful that the statements that are allegedly racist here are pretty. We're not here to defend these statements in any way, shape, or form. But what is deemed to be a racist statement is often in the eye of the beholder. And I think it is far from clear whether if a juror says something about, well, one can imagine almost any variation of this. It seems that drawing it, even based on race, is still a very amorphous line. Or I actually think in this case it's race and ethnicity, which is, again, what does that mean? And then how does that overlap with things like religion? I'm not sure that you can draw a neat line and say this is race.
Given petitioner's concession that even if he wins this case, he's going to have to go back and prove that the outcome of the trial would have it different, not merely that a single juror was racist. What's the big harm to the state's interests here? I mean, it seems to me that there's a great systemic value in having the ability to eradicate this kind of thing. And at the same time, the judges are perfectly able to recognize that in a case like this, the other jurors were far from influenced by this. They were offended by this.
Well, Your Honor, again, I think that they have the burden of showing that a rule of evidence is, including a federal one that this court promulgated, is unconstitutional. And to say, well, maybe you'll win. I mean, if the idea is we've got to vindicate race, I'm not sure that basically a system that creates a regime that's almost impossible for them to win because the other 11 jurors all acquitted anyway, who is that really helping? I mean, what is the justification then for even going down that road? Again, I think this court does not have to deny.
Remedy when there are 5 or 6 racist jurors at the same time. That's what we want. That would be the reason, which happens quite a bit, I would imagine, in this country, right?
Again, I would think that the issue of public confidence could come up equally in the Warger case, when the juror was concededly biased, the juror said basically, my daughter was in exactly this kind of accident, and it would have really destroyed her life. And she expressed her expressed bias in the facts of that case. And this court said, there's other ways to prove that. We're
Right.
not going to go there. And so
We did say there were other ways to prove it, and we unanimously said it in a category that's like the run-of-the-mill kind of situations. But we also flagged and called attention to the fact that we might see cases where something is so extreme that it might call for at least having one more hearing that could, the trial judge who has been familiar with what all unfolded with the jurors
Right.
could actually handle it pretty quickly.
fair enough, but
Pretty quickly.
what the court said in that footnote was cases of extreme bias. Didn't say cases of a particular type of bias. I mean, it could be a very mild comment that somebody takes as a racist comment.
Well, let's look, we actually expect jurors to bring their personal experiences to bear
Right.
in deliberations. And so the line, and we don't actually have a long history of bias based on familial experiences. That's been a real problem for this country. But defining that line between personal experience that comes in and out would have been virtually impossible in the Wargas case. But this race is different. You've said it. We all agree. It has no place at all in the jury room or any aspect of the criminal justice system. It is a poison, and it is a poison that has a terrible history in this country. It's almost easier. It is much easier to pull out and identify and deal with as wrong than the difficult line about personal experience and work.
I agree with you, Your Honor, but again, I don't think the answer is if you have a racial case, then all the rules of evidence go out the window. Imagine you have a Title VII case. There's no rule that says race is so important that we're going to throw out the hearsay rule in Title VII cases because it's so important for us to have to make sure that racial injustices
Nobody's
get corrected.
getting executed in Title VII.
Well, again,
cases.
nobody's getting executed here either. And again, maybe
Nobody's going to prison for life in Title
Well, you're
VII
again,
cases.
but that whether or not the sentence here was 1 month or for life is not really material to the issue before you. This court is being asked to draw a Sixth Amendment rule that would be applicable in all criminal prosecutions. I don't understand this case to be limited to ones involving a particular sentence.
Just so it's clear, your rule is not limited to situations where there's one juror who says racist things. If a majority of the jurors sat around for half an hour before they started deliberating and were telling racist jokes to each other, all involving the group of the individual defendant, and started attributing stuff to him, you think that the rule of evidence that the state of Colorado has, which bars the admission of all of that, is constitutional?
As does this court's rules, 606B would also bar all of that. And that's very much like the Tanner case that this court decided, where I think it was 5 at least of the jurors who were intoxicated and smoking marijuana.
Not a lot like that. It's racism being expressed by a majority of the jurors when they're deciding on the verdict as to a person of a protected group.
Again, Your Honor, the question is, has this person been deprived of their right to trial by an impartial jury? That's the constitutional right that this court is being asked to construe and apply here. The right to an impartial jury. If having your jurors drunk and high and sleeping through the trial is considered to be something that does not warrant further inquiry, if 5 of the 7 or 7 of the 12 are drunk or high, I don't think you can draw that.
In all these cases, we agree that actually they didn't get their Sixth Amendment right. I thought we started that we agree he's been deprived.
And I'm sorry, I
that
didn't.
Right. The
Right.
question is this a case where we have to go no.
Well, it's all no, but it's all about the right. It's all, and that's the point I tried to start out with, Your Honor, to say it's all about the evidence that is admissible. And I think even in that case, this court said we're not going to allow post-verdict juror affidavits to talk about
Of course, that was a case where the evidence of the problem was apparent to anybody who was in the courtroom, including the defense counsel who was paying attention, right? It could have been easily brought to the attention of the court before deliberations were started.
And that was one of the grounds on which that was attempted.
But that's not true in the hypothetical I gave you, right?
Well, but nor was it true in the Wargers case, where there was.
Of course, but that, the question is, how far will you go? Is there no form of misconduct that occurs in the jury deliberation process other than bringing in testimony from an outsider that you would say would be unconstitutional to bar that from admission?
Well, this court certainly did not recognize any other exception. In other words, this court, in enacting Rule 606 and sending it to Congress, could have come up with a residual exception that said, racial bias. And this court, frankly, still can do that. If this court believes that's an issue, this court has the ability to amend Rule 606.
Not Colorado Rule 606.
No, but the federal Rule 606. Again, I think it only underscores the fact
Can I ask
that...
you a question? I confess to not having been a trial lawyer. When it talks about extraneous prejudicial information or outside influences, particularly extraneous prejudicial information, this wasn't just, some of these statements weren't just, here's my opinion about Mexicans. He also injected facts that were extra record. That witness is an illegal. And injected what might have been characterized as expert witness testimony. I'm a law enforcement officer. I have all this experience.
Sure.
Why at least as to those two thieves, where you're injecting statements that assert facts, extra record facts, or extra record expert statements, one, do they meet the exceptions that are already there, or two, if not, why would moving those lines, at least as to grab those types of statements, not work in this case?
I think that goes to the kind of antecedent question to the constitutional questions before this court, which is whether there was a violation of Colorado Rule 606B in the first place, or either the rule itself or it fell into the exceptions. The Colorado Supreme Court concluded that it did, and so that question of Colorado law is not before the court today.
No, I understand. I'm just talking about I'm trying, because I don't know exactly how those facts would have to be different to fall in those exceptions, but it seems to me probably not very much. And so why that margin, as to those comments, not the other ones, as to those comments, the margin between what's allowed in and what they want to keep out here seems to me so infinitesimally small that the constitutional balance, at least as to injection of facts and expert testimony.
It seems to me, if that, Your Honor, the upshot there is that the proper remedy is to, or let's say this were taking place in federal court, that you would just say this could fall within the exception for extraneous statements. Again, what you are being asked to decide, though, is really
No, I get that issue isn't before us, but
Right.
what we are being asked to decide, at least, is whether the line that's there could
Right.
be, assuming we take as given that they don't,
Right.
at least for Colorado, they don't meet that, the line as to those types of statements only has to be moved a teensy bit to capture them.
But
And they
I-
present all the same considerations as the exceptions are
again,
there,
my
as opposed to some of the other opinion statements.
So, but to me, the point you are making is all the more reason to say, maybe the answer here is that this should have been construed to fit within the exceptions to the rule, that this was extraneous.
Well, then the sacrosanct jury deliberations and finality really aren't that big a
But-
deal.
but
If it's just,
again,
I just go back and take
we
care
are
with the
not
rule.
we are not relying at some very broad level about sacrosanct jury deliberations, period. I think my friend is correct that for the most there's a lot of circumstances under which they can come in, but the one exception, the one piece, the one thread that this court has pulled out of that this court, and it goes back in our legal system for centuries, is post-verdict juror affidavits on deliberations.
What I don't understand, I guess to me this all comes down to the question, why is the interest in finality and cutting off inquiry into the jury after the verdict more important than considering whether or not a jury verdict is tainted by race when there's substantial evidence of racial bias?
Your Honor, that has been a societal decision that was reflected in the rules that go back
That's not answering
centuries.
the question. Why do you believe that the court should say that the interest in finality is more important than the interest in dealing with seeing whether a jury verdict is tainted by race when there's substantial evidence of racial bias?
Because, again, I don't think that principle is limited to racial bias. I think you could make that exact argument. Why is the interest in finality so great that it should not allow evidence of any bias by a juror, which was the issue in Wargers? In other words, there could be a perfectly reasonable and rational regime that says statements of bias by other jurors are permissible, or excuse me, affidavits regarding biased statements. What the line that just doesn't work is racial bias or racial or ethnic bias as opposed to all other statements of bias. In other words, it seems to me the only way to rule for my friend is basically to say, you know something, we have been wrong. We think the Sixth Amendment right to impartial jury actually requires an inquiry into bias. When another juror comes, that's a very important thing, and we're going to say the interest in finality is not enough. But that has not been the societal decision that we have made in this country, or even going back to England, where these were decided by games of chance. There's a case from 1799, and the court said, you know, you can't use a juror affidavit after the verdict. They're all, and if so, all the other mechanisms like the pre-juror verdict, the pre-verdict affidavit are okay. We're talking about one narrow part here, that is the part that is, it's just as a matter of evidence, there has been a policy call that this court made. And actually, when this court sent the draft of Rule 606 to Congress in, I believe it was 1975, there was some consideration by the House of making this more of a flexible standard that would allow more of these kind of post-verdict
I don't know
challenges.
if jurors are allowed to raise an issue anonymously with the judge. I mean, there was talking about, look, if you want to communicate a concern to the judge, you've got to send a note through the foreperson. Does Colorado allow anonymous communications, or the juror could somehow get a note to the judge without going through other jurors if they were really worried about getting exposed to the other jurors with this type of toxic charge?
I'm not sure I know the answer to that question off the top of my head, Your Honor, but I do know that what is at issue here is the admissibility. Whether or not you could get a note to the judge is different than the admissibility into evidence. I think at that point,
I'm just talking about a pre-verdict. I'm not talking post-verdict. I'm sorry.
Okay.
Pre-verdict. One of the arguments your friend makes against that being a sufficient protection is that jurors will just feel scared, nervous, intimidated about going to the foreperson, or what if the foreperson's the biased one, or
Right.
that formal process. But if they had a more protective process.
well, again, then there might be an issue whether that kind of a limitation, which is not historically rooted, would raise a Sixth Amendment problem. But that's not the case today. We're squarely within the historical safe zone.
Thank you, counsel.
Thank you, Your Honor.
Strauss, you have 5 minutes.
Thank you, Madam Chief Justice. Just 2 points. My friend emphasized
Before you get to those 2 points, this is a quagmire. This is really, really hard. This is really hard on both sides. And I look at this case and I see milquetoast voir dire by the trial counsel. I don't see any requests that the judge make clear to the jurors that you have this ability and duty to report things. There was no effort here by counsel, at least at the trial level, to use the protections that are available, and then they come here saying those protections don't work. Why should we jump into and cross this very difficult line in a case where you haven't really shown us that the protections that exist don't work?
Well, Justice Millett, I take the point, of course, that this is not an easy case, and the fact that there's a division among the jurisdictions about whether to allow this kind of evidence tells us that there's not a single obviously correct answer. But as for the proceedings in this case, the state made an argument below that we had waived this objection by not questioning on voir dire, and that argument succeeded in the Colorado Intermediate Court, but the Colorado Supreme Court rejected it, and it rejected it
I'm not
because...
talking waiver. I'm talking, maybe this just isn't, maybe there's a dig. This is just, you haven't done your job. Or on this balancing, we don't rule for you this time because we don't have the evidence yet that the protections don't work if vigorously pursued by defense counsel. But in a case, we can add to the footnote now and say if there's a real problem of extreme or racial bias and a showing that other protections didn't work, we leave that open.
2 answers.
Wrong with that ruling?
Yes, 2 answers, Justice Millett. The first is something that I tried to suggest before, which is I think would actually be a mistake to say the solution, or even to suggest the solution to this problem lies in aggressive, intrusive, sophisticated voir dire. I don't think that's something
You want
that should be
intrusion.
encouraged.
You want intrusion. You want it at the back end, not on the front end.
Well, the intrusion at the back end will occur only in extraordinary circumstances. The front end, we could expect it to be more or less routine in these cases, and that will get into the question of, did the trial judge allow enough leeway in the voir dire?
You want 2 chances.
Well, we want a chance in the voir dire, And if there's actually evidence of discrimination at the end, it's not as if, we get to depose the jurors. We're not asking for that. In fact, there are strict rules in almost every jurisdiction that limit counsel's ability to contact jurors, and we have no quarrel
You made a
with those rules.
strategic judgment up front. And it was the wrong strategic judgment. And now we're supposed to blow a hole in lines that have existed for hundreds of years to clean up your strategic judgment.
Justice, but I do want to question the point my friend made about lines existing for hundreds of years. But to get to your question, the judgment was, well, a couple of things, Your Honor. One is it's not obvious what question we could have asked that would have gotten at this. This person, this juror, I'm sure if you said to him, are you prejudiced against Mexican Americans? I'm not sure, but my suspicion is he would have said no. When he made these comments, he was just calling it like he saw it. And I think that is characteristic of the way these cases are going to come up today. You're not going to see overt, unapologetic racism very often. You're going to see things like this, more subtle forms, and those are very difficult to get at in voir dire. The other thing is, I think, this is why, in answer to some other questions from the court, I thought the trial judge is in a position to resolve this. Because if the trial judge's judgment is, look, this is the sort of thing you could have gotten at voir dire, and you didn't. You waited too long. That's a judgment the trial judge can make. But that's something he's in the position to make. If he thinks this was a reasonable thing for the counsel not to raise the question of bias before the jury in voir dire, he can take that into account. I do want to say something that your question suggested, Justice Slaughter, about the centuries of jurisprudence. I mean, that my friend emphasized. I mean, part of the answer, of course, is the history is, in fact, and the current practice is much more checkered than that. We say that in our brief, and the Federal Defender's Amicus brief lays out a lot of the evidence. The other thing is, of course, many things have changed, one of which is, needless to say, our recognition of just how insidious racial discrimination is in the criminal justice process in particular. But the other thing that's changed is the ability of jurors who are almost everywhere free to speak, not only to speak, but to get their views publicized widely. That's changed not only since Lord Mansfield's time, but since 1974 when Rule 606B was promulgated. So you could easily have a situation in which what jurors say about each other is out there in the world, but the one place that can't be brought is before a judge who might put these rumors to rest. And I think the ability to bring issues like this before the judge is not the disease, it's the cure. Thank you very much.
Thank you, counsel. Thanks to both counsel. We're going to take a 10-minute recess to vote. You all have a break, and we'll be right back. Thank you.
They were great. They were much more hostile to you.
Oh, really? I thought they were hostile to you.
Really? Oh, I thought I was unfair. They were.
Oh gosh. No.
Okay. Well, I guess that's good if we both had that reaction. I thought, I mean, come on.
No, I couldn't mean to do appellate. I'm sorry, yeah.
Paper tigers.
Thank you. First, we wanted to thank our two advocates who most of our discussion involved how great you both were, and we have presents. Before we have a ruling, we have presents, which we think
No one's would do this.
what we want. So,
One's a big present and one's a little present.
so Chris and Chris Landau, who's here for the first time, it was great. Thank you so much.
Fantastic.
And and David Strauss, who is a familiar participant, but who we're so thankful that you both obviously prepared so much and gave all of our audience tonight, and then who call it up over the years of such a great, compelling show. And it was actually a very hard case to decide. We were very torn. In the end, we ended up with a 4-3 vote. One of us is recused. Justice Millett is recused, but we ended up with a 4-3 vote to decide this with our 8-member court. And reading for the majority will be Justice Chemerinsky, and then Justice Greenhouse will read for the dissent. And I'll let you proceed.
Thank you. I too express my admiration for the advocates for their terrific job. Orger 2 years ago said that there can be an exception, at least to be considered, if there's evidence of serious bias. This is the case where there's the evidence of serious bias. The statements that were made here cannot be ignored given their racist nature. It doesn't mean that the verdict will be overturned, just that the judge has to consider the jury verdict in light of the statements that were made. If the door was closed here, then what would it mean if 5 or 6 of the jurors expressed similar racist sentiments and made clear that the jury verdict was as a result of racism? There's, of course, the difficulty of confining this, but the courts confine Batson so far to race and sex. This can be confined in a way, too, so it doesn't undermine the sanctity of the jury. The importance of eradicating race means that the lower court should be reversed, and the trial court should consider it in light of this evidence.
This is a hard case, and 3 of us with a certain amount of heavy heart vote to affirm. We're in dissent. There are slippery slopes on both sides. Justice Chemerinsky has just outlined one kind of slippery slope, and I think we think that the respondent outlined another kind of slippery slope. We've got a system that has worked for a long time. We have no particular evidence that it hasn't worked well. Here, there was a failure perhaps of racial fairness inside the jury room. There was also perhaps a failure of advocacy that has served up to us a case that perhaps is not the best case to make a sweeping change in our jury system and to lay heavy burdens on our overworked trial judges. And so we think the lower court, all things considered, got it right, and we would have affirmed.
One last thing I want to say before we actually turn it over briefly to one of the advocates who will be arguing, Jeff Fisher, on October 11th. This is for educational purposes. We don't vote all the time the way we think something would come out or the way we want something to come out. I'm actually speaking mostly for the journalists on the panel, but we go in there thinking we have to have it a divided vote, and we hope that that enhances your understanding of the case. And with that, we are going to take some questions, but we thought we'd first hear from Jeff Fisher of Stanford University, who will be arguing on behalf of the petitioner on October 11th.
Well, thanks. So let me start by just echoing the comments about the advocacy. It was just fabulous. And I have a conversation with David later. Maybe I'll schedule a fishing trip for myself in a couple weeks and see if he wants to go there for me. I'll say three quick things, two of them drawn from the Moot that took place, and one maybe something else in a case that wasn't talked about as much. It was just interesting to me to observe how the slippery slope problems, particularly the ones that are perceived with our position, came out so quickly and so dominated the argument. The state's briefing actually doesn't spend much time at all on that. The state instead spends a great bulk, and the Solicitor General as well, just walking through all the various state interests and trial tactics that would otherwise cure this problem. And so it's interesting to me to see how the argument so quickly moved and focused on that. And so it gives me a lot to think about in terms of how the lines can be drawn, and both as a sort of matter of constitutional text and history, and also as a matter of practicality. The other thing that came out of the Moot that was interesting to me was it would sort of bubble to the surface here and there about the sort of public perception of the criminal justice system, and how this case, in a sense, is being argued at a particular time in this country where race in the criminal justice system is such a big deal. And even down to the detail where the racist juror here was a former police officer. And so how that will play in the justice's mind and how I should think about it as an advocate, I think is a great challenge. But how it'll play in the court's mind in terms of deciding this case, I think will be something really to watch. I thought David put it very nicely when he said, racism transcends just the defendant himself and affects society. Maybe that's a helpful lens. And then the only other thing I'll say that didn't come up as much, which was interesting to me, is the more practical questions. We didn't spend, voir dire came and went a little bit, but then there's various other tools the state and the Solicitor General trot out as being otherwise effective at getting at this problem. And it's striking, at least in the briefing, now maybe it won't take place in the argument, but striking in the briefing, how much of these are really almost empirical questions that just people who are expert at trial would have a sense of. And we don't necessarily have a Supreme Court that is made up of people who have a lot of experience at trial. So how all those pragmatic questions will be dealt with, especially against the backdrop, which we try to make a lot of the various jurisdictions that have had this rule for a long time and haven't experienced any problems, at least any problems that are identified by the other side. I think it's always interesting to see how the court reacts to evidence in the real world and whether it believes it or whether it thinks that, not until we say it, that we don't know what's going to happen. So I think that's something else worth watching in the case. But I'll end where I began. Thanks for letting me watch this. It was enormously educational, helpful for me, and also the justices asked great questions too. In fact, I was actually thrilled to see a way of breaking a 4-4 tie. If I get a recusal,
Recusal
now
after.
I know what to do. And everybody asks me, what if it ties 4-4?
Recusal after argument is better.
Her creative bench, yes, right. Thanks, Jeff, so much. Any questions? Yes, Jack.
Well, what was the breakdown?
It was 4-3.
Yeah.
Well, remember, Jack, you always ask how we voted, but we vote for fun, so it's not going to be very revealing. We will tell you who voted which way, but it will not even tell you anything about us. Erwin, Bob, and me, and who else was to affirm? See, I can't remember. Oh, yeah, and David. And then, that was on the reverse side. And to affirm, it was Linda, David, and Rich. Help? It's.
May I ask a question? Jeff, how do you answer the question if one of the justices says, okay, you have a hearing and it's clear that you've got one racist bad apple on this juror, What then?
racist bad apple in what
In other
sense?
words, you have the hearing, and it confirms that you had one racist on this jury, no question. What then? What?
I think if that juror, if the evidence shows, as it does in this case, voted on the basis of that racism, that is enough. I think a single juror.
See, we went back and forth on that, and so I
You
thought
conceded that that's not true,
that
David. I mean,
was not
maybe-
enough, that you had to go back and prove that this, for example, in Paul's hypothetical, that there were 5 racists and it affected the whole jury. But your view is one racist bad apple is enough.
I think it's similar to what the court has done with court deliberations, where there's a multi-member panel, if one of the members is
Okay, but
biased and votes on that, that affects the entire deliberation.
that actually caused me to switch my vote, because the idea of, because the question is, if you open this door, then what? But because if you open the door and all you have to do is prove that there was one bad guy on this jury, and that automatically, then that's a much bigger deal, isn't it? I mean, that's a big opening. That's opening a big door.
Well, I mean, again, just where I left off earlier, in the states where that door has been open now for decades, that hasn't proved.
Do those states follow that basic rule that
Yes.
one biased person's enough?
The division, that sort of, whether you call it the prejudice or harmless error question that's asked by the states, turns on whether or not the racist comments went to a reason for voting to convict, as opposed to an off-color joke.
You got that here,
Ones
right?
had
So,
nothing to
yeah,
do with the
yeah,
evidence.
yeah.
Again, that's at least what the rule is in the lower court.
Yeah, that's so interesting, yeah. Anyone else?
Anyone else?
Neil, how are we on time? Oh, I'm sorry, yes.
If the basis for the decision is that race is different, this case strikes me as a little odd for that, in that it's ethnicity certainly, but I don't know that that maps up to most people's general notions of race. He's certainly making stereotypes mostly about the culture, but I mean, at least in some contexts, we distinguish national origin from race. I'm just wondering, does it necessarily, does everyone accept in this case that race and ethnicity mean the same thing, that this kind of cultural or social construct of race and what that means? Does he clearly win if the ruling is race is different? Does everyone accept that these are racist comments as far as the posture case?
John,
Yeah,
David
all
wants
the
to.
parties do on all sides, in part because the court itself has conflated, at least in context of anti-Hispanic bias, ethnicity.
Yeah, I sort of prepared for that question, but then you guys didn't ask it. A lot of the foundational race discrimination cases, in fact, involve national origin. Yikwo and Korematsu are national origin cases. The court treated them as race cases. In Korematsu, they came out the other way, but they treated it as a race case. And there's some opinion by Rehnquist, I can't remember the name of the case, where he refers to national origin as the first cousin of race and lumps it with that. So I think that's pretty clearly settled.
But it's a very good question, because those of us have to write about it. If you write a story that says, this is a story of terrible race bias during, jury deliberation, most readers are not going to think, oh, he was made comments about his Mexican heritage. Most people, I don't necessarily, people in the law business might think that, but that's not automatically what people would think.
And for what it's worth, there was actually a Supreme Court case that acknowledged or addressed the large overlap that can arise between race discrimination, ethnic discrimination, and religious discrimination, that there tends to be a huge overlap in that area. So your ability to sort of, if they remember that case, back away from the religion line is going to be hard.
We're going right into the next panel as soon as the justices leave. But again, one last round of applause for Chris and David.
Does yours say Landau?
Better be the same.
Yeah, I mean, yeah.
This is fun. This is a lot of fun. This is great. That was a lot of fun. You guys were great. That's such good questions. So much more reasonable than the real ones. I was complaining about this. You just want to avoid embarrassment, so you have to prepare.
I was saying that, I don't know how it was with you when you were in private practice, but I love it when
basically oral argument is just questions? Because I don't get nervous when I'm answering questions, but I get nervous if there's silence.
Yeah, you're up there listening to yourself talk.
Yes, yeah, it was so, yes.
I was actually was.
Yes, yes,
Yeah, I
thank
actually
goodness.
thought you. I was surprised you let me go on for so long.
Yeah, me
I
too,
expected to
me
be
too.
interrupted. Yeah,
Oh, they were great questions.
the questions are really good. That was really civilized. Former student of yours. How are you? I'm very well. Dr. Meats. I'm good. Exactly. I am good. I'm doing great.
So he has connections to both of us because you were his prof and I was his co-clerk.
Is that right?
Yes.
Scalia, yes. Way to make me feel old, you guys. Thanks. I appreciate that. That was great. I really enjoyed it. You guys both did a great job. Thanks. Yeah. I was just thinking about you because one time when I was here in some previous visit, you took me to some great student coffee shop. Oh, did I? We had coffee. Oh, okay. And I was trying to recreate it so I could go there and work on this. Oh, I'm sorry. So okay. Could aromas. That's probably it. Yeah. Not that many. Because that kind of rang. That's the place. Yeah. I thought I'd email you and ask you. I thought that's really goofy. Oh, I would have gladly responded. Yeah, that would be great. So you're not any panels tomorrow? Or? No, this one tonight. No. Okay. And not tomorrow? Away from leisure, but I got to leave midday. Yeah. Okay. All right. I can't come tomorrow. My son has a soccer game. First priority. He really is. Soccer, right? Yeah. My family has no prior connection to soccer. Zero. I told Chris I know nothing about it. Me, I have some, yes. But my son's adopted, so he doesn't. It's nothing for me. Believe me. He's much better athlete than I am. So yeah. That's great. Yeah, that's really cool. That's where I'll be tomorrow. So where's the game? It's here in Williamsburg. So it's a statewide tournament that because they're seeded high, they get to be the home team. Is it traveling for you? Yeah. Great. Yes. What position? He plays left wing until they get in trouble, in which case he goes straight. Wow. Yeah. So okay. I'm sorry. Good seeing you, James. You're gonna be here? You're gonna stay here? Yeah. Okay. Well, I'll send you an email about James Kaplan. Please do. Absolutely. And good to see you, buddy. Thank you. Good job. Yeah. Enjoyed it. Yeah. Chris, thanks for calling. Hello, Greg. It's been a long time since I've seen you. We spoke on the phone from time to time. I haven't seen you since my
No, that was definitely new. I walked past it and I realized it was you. I apologize for letting myself get replaced by somebody much smarter than me.
Oh my gosh, you get your vote. Wow.
That was the biggest surprise. When I heard that Justice Greenhouse was in the Senate, I said, surely I I'll ask you some time. I had one question I really wanted to ask there that I actually don't know the answer to.
I'm glad you did because I probably wouldn't either if you don't.
Actually, I probably would have asked you.
Where are your kids in school now?
I don't know if it's ever happened.
So you live in the district?
I'm in the district. How about you?
Our kids are both in single-sex Catholic schools. We have decided that
Just argument.
it's clear to us that they really benefit from the structure there. I mean, they just need like kind of kernel, and so it's funny. I would have never thought. I never in a single day of my life was single-sex school. My son goes to St. Anselm's Abbey, and my daughter goes to Stonefield. And they're great places. Okay.
I might boot
nice to
Adam
see you.
whenever he talks.
Thanks for stopping by.
I'll catch up with you later.
Perfect.
Dinner?
Yes.
Welcome. Topic tonight is the support in the 2016 election. This topic is very fast moving, other parts are a little slower moving. In the fast moving department just today, we had Ted Cruz announce that he would vote for Donald Trump after months of searching for the punches. Part of the search of Ted Cruz's Trump has expanded his short list. It's no longer very short. It has 21 mostly judges on it. So he's accomplishing the feat that Richard Nixon accomplished with his enemies list if you were a journalist in Washington. If you're not on that list, it makes you a little bit insulting if you're a conservative judge. So with me tonight to discuss this exciting topic, I'm Adam Lichtbeck from the Supreme Court of the New York Times. Are four fantastic experts, all of them known. I'm going to introduce them just very, very briefly. Pam Karlan is back at Stanford Law School after a very successful 2-year run in the Justice Department's Civil Rights Division, focusing on voting rights. Neil Kajal is a former acting solicitor general, now a partner at Coken Levels, also a professor at Georgetown Law School. Canon Shanmugam is a partner who lives in Connolly and watched the last argument with particular interest, having argued the Workers' case. David Strauss is a professor at the Chicago Law School, and all of these folks are real students of the court and of the nomination process, and some of their names were mentioned in at least some context in the nomination process. Let me start with that question that everyone asks me, civilians, others. I'm going to start with Ben, then down the line. Wither, what happens to Merrick Garland?
Well, one of the great things is that you can always say it depends. It depends. If Donald Trump is elected president, I am 100% confident, because he does not appear on the list of 21, indeed he probably wouldn't appear on a list of 2,100 people that Donald Trump would nominate to the Supreme Court. His nomination is dead. If Hillary Clinton wins the election, I think he has a fairly good chance of being renominated. Because the political capital, I think, that a President Clinton would have to exert to nominate somebody else, unless she has a filibuster-proof majority in the Senate, might not be worth it for her.
Will you share that view?
Yeah, largely. So I do think it really turns, I think, obviously, as Trump thinks, right, if Secretary Clinton wins, I think, and the Democrats take the Senate, I think even with 51, I think there will be enormous pressure on her to move away from Garland. I think it's very hard for her to move away from Garland. However, after so many people have said he's the most qualified nominee ever in the history of the Supreme Court, at a time when she's going to want to be confirming her cabinet and doing a whole bunch of other things, it's tough. But if there are 51 Democrats in the Senate, you know, I could sure see a lot of pressure and it happening, because they could go nuclear and eliminate the filibuster.
Well, first of all, it's great to be here. I'm also happy to have laid down my life on the Werner case, Daniel Rodriguez case. It's really within my area of expertise. This is more of a political question than a legal one. But I have to think that it's very, very likely that President Clinton would renominate Chief Judge Garland. He has such enormous respect and support in legal circles, among people who are influential in Democratic political circles. I think it's just, she would be taking on too much to pull him back and nominate someone else who might be more controversial, particularly, as Neil says, at the beginning of a presidential term. So while I understand that there's a political imperative to suggest that that possibility remains live, it strikes me as pretty unlikely.
David, before you give your thoughts, I'm not sure that the evidence supports these last views, given that we went through an entire convention without anyone mentioning his name, that when Hillary Clinton has recently been asked about whether she would renominate him, she said, I would search far and wide in a diverse body of candidates, and that it might also be seen to reward Republicans for their intransigence, to give them what they drag their feet on for an entire year if she wins the presidency. Having let me ask that compound question, what do you say?
I guess I also think it's a little more complicated what will happen in the event of a President Clinton. I mean, I agree with Neil's suggestion that the filibuster may very well be gone. I think either way, I think I would expect a party with a majority of the Senate, if they need to, as Neil said, go nuclear and get rid of the filibuster rule. I think what would happen if President-elect Clinton signaled that she would like to appoint someone else, I think what would happen is Chief Judge Garland would withdraw his nomination, would ask the president to withdraw his nomination, and would act as if this was his decision. And that would, to some degree, clear the ground for her to go ahead. And he would say, you know, she's a new president, she has to make her own decision and do that unequivocally. And so that the idea that she would be rejecting him, while people would have some sense it went on, would be buried. And I think that would be the scenario in which, if she decided she wanted to appoint someone else, in which that would happen. The other thing is, I could easily see, if she wins, Republicans confirming him in a lame duck session. despite the protestations that this was all about allowing the new president to choose. I think no one really buys that anymore. And I don't think President Obama will withdraw him in the lame duck session. I think President Obama will not do that. I think he thinks this is the person who should be on the court, and the idea that he would now engage in a bit of what will look like political gamesmanship with the Supreme Court after having said that's what he's trying to prevent the Republicans from doing. I don't think that I don't see that scenario at all. But I think a lame duck confirmation is a distinct possibility.
Other thoughts on the lame duck? Obviously, it's the only rational move for the Republicans should Hillary Clinton be elected, and yet they say they won't do that. What's going on?
You're asking me to say what's going on with the Republicans.
It's a hypothetical.
It's like asking me if I had a sister, what would she have had for lunch today? Baloney. That's good. So much of this depends on things that are really hard to predict, because some of it depends on whether the Republicans think that Hillary Clinton wants to expend a lot of capital on trying to get somebody else through rather than Judge Garland, who, it's important to remember, was a high-level Justice Department official in the last Clinton administration. So it's not as if he is unknown to the Clintons. And, I think it's 100% sure that if Hillary Clinton had been elected and the vacancy had opened up after she had been elected and there was a Democratic majority in the Senate, she would not have nominated Merrick Garland. But that's not the world we live in. Going back to the lame duck, some of it depends, who knows whether the whole lame duck is taken up with a bunch of credentials challenges under the Electoral Count Act to the various electoral votes from various states, because the one thing I don't see happening after Election Day is Donald Trump giving a concession speech. And so if there are states that are close and there's a lot of time taken up during that period in trying to figure out who won the election and the like, there's not going to be a lot of time for a lame duck Senate session in which they do a kind of frog march set of hearings and then vote him through.
Well, and if there's an electoral contest that might end up at the court, it may be not in the Republican interest to have a 9-member court.
Right, and then of course there's the kind of, to kind of borrow from the Olympics, the 2.5 reverse double somersault inverse, which is the Democrats take the Senate and the Republicans win the presidency, and the Democrats between January 3rd and January 20th confirm Merrick Garland to the Supreme Court, because the new Congress comes in on the 20th and the new president doesn't come in, comes in on the 3rd, and the new president doesn't come in until the 20th.
All right, so there are many scenarios. Let me ask a question that I think I need to ask just to clear the underbrush. Is it plain to all of us that if Donald Trump does succeed in appointing someone to the Supreme Court, nothing fundamental changes in the direction of the court?
Well, first, let me just say something about the premise. I think, and maybe I should have said this at the start, the idea that we would have a judge like Merrick Garland wait almost 200 days and counting for a confirmation hearing is unconscionable. And so even people like me who are inclined to turn the other cheek when it comes to confirmations and, presidents getting deference and so on, I do not think that would happen if we have a President Trump. I think even the moderate side of the Democratic Party will fight tooth and nail and say, look, if you can't confirm Merrick Garland, then who the heck are you going to find that we can confirm? And so I think there's a very long possibility, obviously it depends on the Senate and their votes, of the Supreme Court being shorthanded for a long period of time. Having said that, if there's a Trump nominee to replace Justice Scalia, I think you'll see some changes. I think particularly in the criminal area, actually the court might move a little bit more in the direction of the government because Justice Scalia was such a leader, and we can talk about that later. But I think that's one area in which we'd see change.
Other thoughts on a fifth Republican appointee?
Yeah, I think, well, two thoughts. I mean, I think what first of all, what Neil said about the Garland affair I think is right. And one thing, or could very well be right, and one thing that really worries me about this is whatever the outcome, the damage to the court has been done. Because it's hard to imagine, the Democrats, if in the foreseeable future, should they be in the position the Republicans were in now, unilaterally disarming. They'll remember this because that's the way these things work. And if they are ever in the position to block a Republican appointee, however moderate, I'd expect them to do it. And that's terrible. It's a terrible outcome. And I think exactly what President Obama was trying to avoid by appointing the person who would be most acceptable to the Republicans and resisting a considerable amount of pressure he got from his supporters to appoint someone who would make a statement, rally the base. The argument, the Republicans aren't going to confirm whoever you nominate anyway. Why not appoint someone younger, more left wing, maybe a member of a minority group? He didn't go down that road just because he didn't want this to happen, and I'm afraid it'll happen. The question of a Trump nominee, I mean, yeah, he has this list of 21 or 45 or however many, but the guy is not really, I hope this isn't unfair, he isn't always entirely 100% consistent in the positions he takes. And it wouldn't at all shock me if when he gets elected president and he's riding high, he tosses the list out the window. And
but he's made a solemn commitment.
well, that's true. I forgot that part. He has a sister who is a judge, whom he might listen to, who is not certainly not a moving conservative. I don't know exactly what her views are. And if his daughter tries to persuade him to appoint some middle of the road woman who might be pro-choice, I wouldn't. Who would be shocked if he listened to his daughter and did that? So I think it's like lots of other things, like the possibility of nuclear war. It's a wild card.
I would just say two things about this. The first, probably obvious, and the second, maybe less so. The first is that, assuming that there's a President Trump, the person who is nominated is going to have enormous shoes to fill. I think that there is a tremendous void on the conservative side of the court, given Justice Scalia's intellectual leadership, and that's going to be a challenge for any nominee of President Trump, and frankly any like-minded nominees to follow. Second, I understand that there is obviously a lot of blame in the confirmation game, and it points in both directions. And if you pump enough drinks into a leading conservative or a leading liberal, they'll eventually go back to the Bork hearings or the Thomas hearings or even further back and attempt to attribute blame for this. But with regard to this nomination, I think that there's a certain amount of feigned outrage. I just think that the reality of the situation is that if you had a Republican president in a Democratic-controlled Senate and a vacancy that arose unexpectedly in the last year of a presidential term, I think the shoe would be on exactly the opposite foot, and we would have similar gridlock. If the nomination were, as this one is, a nomination that is effectively going to decide the direction of the court. And I think that this would have been a different situation if it had been one of the more liberal members of the court who had unexpectedly passed away, and there were more of a like-for-like replacement. And I really don't think that there can be any doubt that if Chief Judge Garland is in fact the next justice on the Supreme Court, it is going to lead to a sea change in the direction of the court on many of the most consequential issues of the law.
So I want to follow up on that last point, but first I want to see if there's any dissent on this proposition that if the shoe were on the other foot, we would have seen exactly the same kind of conduct by a Democratic-controlled Senate.
Well, at least in the past, we haven't seen that kind of conduct. Justice Kennedy's seat, which was a swing seat, was it ultimately was a confirmation in the last year. It took a number of nominees before they got a confirmation for it, but it was a confirmation. I think one of the differences here is that, and this may just be my own biases, that if you believe in kind of fairness as a fundamental principle, it's harder to be unfair than if fairness is not a principle that is at the center of your political organization. And I just feel that the Democrats and the Republicans are asymmetrically organized here in part, and this goes to the question that you started by asking, which was about if President Trump nominated or nominated the next justice on the Supreme Court, would things change? And the answer to that is yes, because Donald Trump is not part of the movement conservatism that if you go back to the Reagan administration OLP memos about where they wanted to move the court. He doesn't care about any of that stuff as far as I can tell. He doesn't care about originalism. He doesn't know anything about our history. He doesn't care about textualism. He hasn't read the Constitution. And if he read it, he wouldn't see in it what everybody else sees. And the result of that is he's a total wild card when it comes to who he would nominate. But I don't think that the Democrats would have been able to organize themselves to reject somebody like a Justice Kennedy if that person had been nominated in the January or February or March of an election year. I just don't think they would have found themselves capable of doing that. Perhaps because, to go back to the old Will Rogers line, I don't belong to an organized political party. I'm a Democrat.
But in fairness, Pam, I mean, there's been a lot of water under the confirmation bridge since
And so we
1988.
don't know whether that water would change things. It's just the evidence of what we've already seen is that the Democrats and the Republicans have behaved differently on this. That is, the Democrats confirmed Justice Kennedy very quickly, right? I mean,
Well, in large part because of what had happened in the 7th year of the Reagan presidency with the Bork nomination.
But I do think it's fair to also point out who those nominees were. Merrick Garland is quite a different nominee than Robert Bork. So you could imagine different degrees of opposition. I think the president here did something pretty remarkable in putting up someone who is such a centrist, who does have the respect of so many people across the political aisle, who served with distinction on the DC circuit in a way that, I do think it's fair to say no other nominee, certainly in our lifetimes, has had anything like
But don't
those
you think that
credentials.
was precisely because of the calculation that by virtue of the fact that getting a nominee confirmed in the last year of a presidential term was going to be hard, he was going to pick the person who he thought had the best chance of success?
Yes, and I'm saying that if you're going to claim that the shoe should be on the other foot, you'd have to ask if the Republicans put the equivalent of Merrick Garland up, do you think the Democrats would have confirmed him? I think the answer to that is unequivocally yes.
Can I just, there's a deep issue here about, that we sometimes lose sight of, that we have the Constitution, we have various principles of constitutional law. There are also a lot of norms that are really critical, maybe indispensable to the way the government functions. There are things that are just understood, and they're not written down anywhere. And I think at least one of the norms was, and maybe Cannon's right, that there's been too much water under the bridge, over the dam, wherever it goes. But at least one of the norms was, look, if the Senate is in our hands and the presidency is in your hands, we're not going to block everyone, but don't send us someone who is extreme. I mean, not extreme in the sense of they're crazy, but kind of at the edge of your party. And there were reports that before Bork was nominated, Senator Biden, then chair of the Judiciary Committee, actually met with people in the Reagan administration, and they showed him a list of people they were thinking about. And the report is, I don't know if this is true, the report is that Biden went down the list and said, not that guy, not that guy, not that guy, the rest of them fine. And one of the not that guys was Bork. But they sent him up anyway. And the understanding was, it's got to be someone from the center of your party if we control the Senate. That was the understanding. Now, maybe Cannon's right. That was, that's long since disappeared because of what happened with Justice Alito or Chief Justice Roberts. But those norms, I think, one of the troubling things about what's happened in Washington is those norms are disappearing in lots of arenas. Refusing to confirm presidential appointees because you disapprove of the program they're appointed to head, things like that you can't point to a provision of the Constitution and say, see here, it says this and you violated it, but we need those in order to function. And if those have in fact disappeared, and maybe they have, I don't know, but if they have, and I think if they haven't already, I think the Garland episode will wipe them out. I think that will be a big loss, and it's a sort of loss that those of us who focus on constitutional law, and particularly those who sort of think the Constitution is, the text and what you can read, won't see that.
Can I just clarify one thing? I mean, I'm not here to relitigate the Bork confirmation, in part because I'm barely old enough to remember it. But
thank you, Ken.
I thought that applied to you too. But I think that the norm that we're talking about is really a different one, which is the norm of whether you would confirm a nominee in the president's last year. And quite frankly, I just don't think that there are enough data points to be able to say that there is a norm, because we have just not had that many vacancies that have arisen in the last year of a presidential term, and there's a lot of debate. You can argue that the Kennedy nomination qualifies, but I think that's the real question.
But why the last year? Why not the year after you're elected? You say, well, you know, that this wasn't an issue in that election. The American people need to decide it, so we'll just hold the seat open for 3 years. I don't see any magic about the last calendar year. And to the extent that the Constitution has anything to say about this, and it doesn't have a lot, there are two things it does say pretty clearly. One is the judges are not supposed to be elected directly. Indeed, in the original Constitution, even the people who nominated and confirmed the justices weren't elected directly. And when the framers of the Constitution wanted there to be an intervening election before something happened, they knew how to say that. That's what the 27th Amendment
They did give the power to elected officials, and certainly the Constitution says nothing about the timing of the Senate's act to consent.
Yeah, but if you really think that, then why, as a principled matter, why is the last year any different than if Justice Scalia had died in 2009? Why wouldn't it be just as principled for the Republicans to say, you know, we need to wait for the next election?
Let me turn to a point that Ken raised a couple minutes ago. Let's assume that Hillary Clinton wins, and let's assume that Merrick Garland or some other Democratic appointee comes on the court. Does that fundamentally reshape the direction of the court? I mean, you would think that at a minimum, Justice Kennedy is no longer the median justice. Either the new justice or Justice Breyer becomes the median justice. What sort of difference does that make in the direction of the court, Neil?
Yeah, so I think it makes some difference. I don't think it's, it's necessarily huge changes. After all, a lot of the big things that, are actually ones in which the court already has a so-called liberal majority abortion and affirmative action. Now that Justice Kennedy has voted that way are two recent examples. Obviously, there's others in which you'll see changes like the Texas immigration case, which was deadlocked 4-4. But I would say, the changes on the big social issues may not be as dramatic as they might have been with other lineups at other earlier moments in time. I think the business cases changed quite a bit. I think that Chief Judge Garland will vote differently than Justice Scalia, who's a leader in the anti-class action kind of fighting class certification and things like that. So, I think labor issues may change and employment issues. But I think a good number of the big social issues are pretty much already decided.
Yeah, I think another sort of little bit of a sleeper issue here that we might see a dramatic change is in doctrines of administrative deference and administrative law. The Chevron, the doctrine that the court will defer to an agency interpretation of the statute it administers, that was really in the crosshairs of a lot of the justices. Justice Scalia had, early in his career, been a proponent of Chevron. He was very clearly edging away from it at the end of his career. And I would think that especially someone coming from the D.C. Circuit, I don't know what Chief Judge Garland thinks about this, but he comes from the D.C. Circuit. He's used to dealing with administrative agencies. I think he's favorably inclined toward Chevron. It's sort of part of the fabric of his professional life. And those doctrines are going to come under a lot of pressure if we continue to have a situation in which the Democrats seem to have a built-in edge in presidential elections and the Republicans a built-in edge in congressional elections, because Democratic presidents will try to accomplish more and more things through administrative agencies and through executive power, and that'll be a major point of litigation. And the current court, as I said, there was a lot of anti-administrative agency rhetoric coming out of the current court and movements on doctrine, and I would think a Democratic appointee was likely to reverse that.
And if you kind of add one additional layer to that, I think the kind of mounting that you see, in case after case, an additional QP on should our deference be gotten rid of. I think that's dead.
Right.
Yeah, though ironically enough, there's one very high-profile case that potentially presents that question.
There's something about it.
I mean, I would just add a couple of other areas of the law where I think there might be dramatic differences that are manifested sooner rather than later. The first is in the area of class actions and arbitration, where there are a number of pending issues that are really issues that in the prior court looked like 5-4 issues, and if we have a Justice Garland, he'll immediately be put to the test on those issues. I think the other really significant area is in the area of criminal law, and specifically in the area of
both substantive procedural rights and the interpretation of criminal statutes. Those were both areas in which Justice Scalia, particularly toward the end of his career, was relatively friendly to criminal defendants. I don't think we have a lot of data points on a potential Justice Garland, since he sits on the D.C. Circuit, which has very limited criminal jurisdiction. But I think those are two areas in which we might see changes. I think overall, I think the one thing to really kind of keep an eye on is if we have a quote unquote liberal majority, 5 Democratic appointees on the court, it's going to be interesting to see if they proceed in relative lockstep, as the 4 more liberal members of the current court have, particularly in recent years, or whether once they have a majority, they start to sort of splinter. And the line on which I could see them starting to splinter is in the willingness to revisit past precedents with which they disagree, cases like Citizens United. And I just kind of wonder whether there may be some members of that majority, and I would identify for instance, Justice Kagan as potentially being one of those justices who take more of the long view, a go slow approach, whereas others may proceed more quickly.
It's easier to take a long view if you're 56 than if you're 83.
So I'm told.
Did David tell you? How does Chief Justice Roberts adjust if there are 5 Democratic appointees on the court? In his 11 years, he has led a court dominated by 5 Republican appointees, led a conservative-dominated court. It would seem to be an uncomfortable and not often seen in our history position for a Chief Justice to be in perpetual dissent in the closely divided, politically charged cases. What does a Chief Justice do in those circumstances, Pam Carlin?
Well, one of the things is he moves slightly to control the assigning power to the extent he can. He looks for doctrines that will enable him to be on the side that's going to win on the bottom line, and then control the assignment in some ways to try and move the court as subtly as he can in the direction he wants to go.
And of course, the Chief Justice who did that historically, at least in his early years, was Chief Justice Berger, much to the consternation.
I still remember just as like when you see this imitation of Chief Justice Berger coming out of the conference, and he would read the notes and he goes, and then the Chief Justice would say, well, I could affirm as well as reverse.
It's certainly one way to retain the assignment power, if you, in fact, vote in both directions.
Or you assign it and then you change your vote in dissent.
Well, and there's an analogy to Rehnquist, isn't there, as well?
Yes, that's the analogy I would make, that that one Justice Rehnquist was sort of known for writing Lone Ranger opinions in 8-1 votes. When he became Chief Justice, you didn't really see that, and you saw him really seemed to take the role more seriously and try to position himself more in the center of the court and write some opinions on Miranda, on sex discrimination that seemed quite surprising coming from the former Justice Rehnquist now that he was Chief Justice. And of course, the Chief Justice Roberts clerk for Justice Rehnquist. And I would expect, I mean, there aren't that many issues, I think, on which the current Chief Justice is so deeply invested that he's incapable of being flexible. I think there are some. I think affirmative action is probably one of them. But affirmative action may no longer be alive for the reasons that have been said. But I think on a lot of issues, he's shown a degree of flexibility already. And I agree with with Adam and Pam that it's very difficult to imagine a Chief Justice, at least one who is actively engaged in the court, which this one certainly is, sort of contenting himself with being in perpetual dissent. I just don't see that happening.
Yeah, your predecessor, Linda Greenhouse, who's still here, and she can correct me if I mischaracterize this, wrote an interesting piece, I think 2 or 3 years ago, the thesis of which was that the Chief Justice, in some sense, was looking ahead to this moment, knowing that there was going to be a point in his career when there would be an inflection point in the makeup of the court, and some possibility that he could find himself on the dissenting side on a lot of major issues. And I think that would have to be true. I mean, the Chief Justice, of course, is very savvy, very talented, and someone who I'm sure realized that with a court that was divided 5-4 on many of the most consequential issues, presidential elections sooner or later could tip that balance in one direction or the other. And I do tend to think that he's going to want to be in the game, that he's not going to take himself out of the game by being perennially in dissent going forward. But what that means
from issue to issue is clearly going to vary. There are certain issues like affirmative action where he clearly has kind of nailed his colors to the mast already.
The other thing is to keep the court from deciding those issues in which he's likely to be in dissent on this 5-4 court. He will wait until, you know, this 5-4 is not going to be the 5-4 for the next 20 years. I mean, there are a lot of other people on the court at this point who it's predictable will not be there 15 years from now. And so, and he's not one of those. And so to the extent he can prevent the court from deciding the issues, you know, don't grant cert on cases, even if it's a bad decision from a lower court. Wait until maybe you have 5 votes again.
And I guess the alternative, if the chief is in dissent on this hypothetical new court with 5 Democratic appointees, is Justice Ginsburg becomes the de facto first female chief justice, assigning the decisions in the major cases. And I'm pretty sure she's told me this, she has never in her career assigned a majority opinion. And even on the current court, it would require the liberals plus Alito, and that's a combination we haven't seen yet.
I mean, that's plainly correct, given the seniority. I certainly can't think of a case to contradict that, and I wonder whether...
But if that seems wrong, raise your hand.
Yeah, there are a lot of smart people in the room. But I wonder whether that also might deter Justice Ginsburg from retiring sooner rather than later. I mean, it's very, you know, for someone who's been on the court for so long, finally to be in the majority has to be quite attractive. And so if we have a President Clinton, it will be interesting to see how that affects her decision-making, the decision-making of Justice Breyer as well.
You mentioned also, Cannon, that there is some precedence that at least some of this new 5-member liberal coalition might be inclined to revisit. When I interviewed Justice Ginsburg in July, she mentioned Heller and Citizens United as 2 things she might like to do. Shelby County she mentioned also, but she didn't see a mechanism to revisit Shelby County. Do you think those precedents get overturned, cut back? We don't go further down the road? What does a majority do with some of these decisions?
I'd be surprised if you see those getting overruled, at least right away. Citizens United has obviously become this kind of liberal rallying cry. So maybe that's the one becoming almost a de facto litmus test for Democratic nominations to the court. But both of them, both guns and campaign finance, are ones where I think that there's so much play within that with those decisions themselves. You don't have to overrule Citizens United. You can take the Breyer-esque view of more speech, campaign regulation being ways of actually adding voices, and so you don't have to go and overrule Buckley and the idea that money is speech and something like that. And obviously with Heller, there's all sorts of language in the opinion, which lots of lower courts have used to say, okay, fine, it's an individual right, but that doesn't mean you can't reasonably regulate it in all sorts of ways, concealed weapons, assault weapons, etc. So I'd be really quite surprised if we see this in the next few years, particularly since Justice Kagan has made something of a career over the last 5 years in saying stare decisis is really important, go slow. And so at least her vote, I think, would be tough to get if there were massive challenges to those things.
Yeah, I think I agree. I think Heller is the liberals are to Heller as some of the conservatives are, I think, to Roe against Wade, which is we think it's a terrible decision. But if we ever wrote an opinion saying that decision is hereby overruled, there'd be tremendous backlash politically, and we don't have to write that opinion. We can just eat away at it, as has been done to a degree to Roe, and as it has been done de facto to Heller as well.
On the court that existed until February, a lot of conservative movement litigators put together a lot of text cases, very, very, very successfully, very savvily, and they thought they were pushing on an open door. Sometimes it worked, sometimes it didn't. If the majority flips, I would think liberal movement litigators who've tried hard in recent years to keep cases out of the court might like to bring some cases to the court. What are the issues that the left might like to bring to such a court?
Well, one issue I think is some version of death penalty stuff is going to go back up. Long-term solitary confinement is going to go back up because they already have some sense that Justice Kennedy is prepared to move on that, so that it's not just what are you going to get from the 5 more liberal justices. My guess is that people will start bringing redistricting cases back to the court on some theory or another. There's a bunch of cases burbling up through the system. Voter ID cases are burbling up through the system. And so trying to get the court to put some more teeth into the undue burden standard in voting. Those are things that I think, don't require massive changes of doctrine. They require sort of reading the doctrine more robustly. I mean, the death penalty requires a big change, but the other ones don't really require big changes. They require kind of incremental movement.
And I think there's a converse side to that, which is that it's going to be very interesting to see how the business community approaches a changed Supreme Court. And that may very well depend on the area of the law. But certainly, you could see groups like the Chamber of Commerce becoming somewhat more parsimonious about their efforts to support cert, particularly in cases where it looks ex ante as if it's going to be difficult to win on the merits.
Let me ask you about some of the political commentary we've heard from One First Street from Justice Ginsburg. Was it out of line for her to express views about the presidential candidate? Not everyone all at once.
Well, I'll start. I do think it was. And, it wasn't just the comments about the presidential candidate, which is amazing that you and Joan and, others got these interviews, and it's incredible. But
terrific journalism.
It was terrific journalism. But the idea that, she would go on and opine about how her colleagues would have voted, like Justice Kagan in the affirmative action case, but for the fact that she was recused, or what the voting lineup was in the Texas case and so on. There's a lot of stuff in those interviews just apart from the presidential election, which I found really pretty troubling. With respect to the presidential election, too, I mean, if you do have a President Trump, well, I'll be deported, so I don't care, but, y'all, you really do want some semblance of, you want the appearance to be a fairness, and you don't want it to be that every time she votes against the Trump administration, it's, oh, well, what she said before the election, that she'd have to move to New Zealand, and it's unthinkable, and so on. I just think it's really corrosive. And, sure, judges have some speech rights and so on, but I think if you're on the Supreme Court, you keep your political opinions to yourself.
I mean, the thing I regret is if she was going to say something that what she didn't say was, look, I don't take a position on political candidates or anything, but to attack a federal judge like Judge Curiel about his ability to decide a case fairly because of his ethnicity is something that nobody should be doing. I mean, that would seem to me to be as far as you could really go as a sitting justice in an appropriate way to talk about things, because I think somebody needs to defend judges, and it's a good thing for the justices of the Supreme Court to defend the federal judiciary against attacks.
Yeah, I'll just add one thought on this, which is that it sort of illustrates something that has always seemed a little bit peculiar to me, which is that pretty clearly if a lower court judge had made similar statements, it would have violated the Code of Judicial Conduct, but that code does not apply to Supreme Court justices. And I've never really heard a very good explanation for why that should be the case.
Should a Bush v. Gore type case reach the Supreme Court, would she be obligated to recuse herself?
No, I don't think so. I mean, I think recusal rules at the Supreme Court are so difficult, that it's so much given to the individual justice. There's almost no standard, in part because, as Cannon says, the judicial code doesn't apply. So it's very hard to see how, obviously depend, but I think it's very hard to see how she'll be forced to recuse. But it just demonstrates again kind of the unfortunateness of those remarks that were made.
It's hard to see.
Justice O'Connor didn't recuse herself in Bush v. Gore after saying at that cocktail party the night of the election, "Oh, this is terrible, this is terrible.
Oh.
Now I won't be able to resign."
We have about 10 minutes left. Why don't we turn to your questions? Jack.
I'd like to close the loop on the Garland thing. Something almost said, but not quite. When Garland was nominated, a lot of people expressed an opinion as to whether Obama had the right, not just the power, the political stuff to make the nomination stick, but a right to do it at that point in his term. And of course, Obama said, no, I've been elected for 4 years. That's a bit like what Pat was saying, you could cut it any way you want, but I think that Hillary Clinton would have a real stake in vindicating Obama's right to finish his term with a nomination, so that she would have it. If she's elected, then she has 4 years and a 4th year. She'd have a real stake in vindicating the Garland nomination.
That's kind of meta. I mean, I could imagine that being a calculation, but really, honestly, it doesn't strike me as a very big one. I think, I do think that she's going to approach this with, hey, this is not my only turn at the rodeo if I'm president. I'm going to have at least a couple more. And it's really interesting to think about once she's playing that long-term game, how is that going to influence things? In my judgment, it means that she's more likely to stick with Garland because she's going to save her capital for the other ones. But I do think that, there's interesting things at play. I mean, she very well could be the first president to turn the Supreme Court into mostly women justices. I mean, that is not at all within the realm of, outside the realm of possibility, even in just the first term, let alone the second. Indeed, I think we can staff it with people in this room. So, that long-term vision, I do think is going to be there, but I think mostly that just cuts in favor of Garland for the political reasons of not having a fight.
Yeah, and I would just add that, I think that there are sort of two separate questions, but it's an important distinction. I think on the issue of whether the president has a right to get his or her nominees confirmed within a certain period of time, there really isn't a colorable argument that there's some sort of constitutional entitlement. I think this is really a debate about what the appropriate political norm should be. And I think as the discussion has illustrated, we can have a vigorous debate about that, but ultimately that's a political question, whether we should in fact have a world in which when you get to a 4th year of a term, the nominations process comes to a juddering halt. And I could argue that on both sides as a political question. But I think as a legal question, the argument that there's some sort of constitutional entitlement is, I think, belied by the text.
And two thoughts about this. I'm not sure she can vindicate his right anymore. I think the damage has been done. I mean, they've blocked the nomination, even if they confirm it in the lame duck. I think that's happened. The other thing is, and this goes generally to these discussions we're having about the president's decision. The nomination process is, we think of it as the president's, and of course, in some sense it is, but a lot of this is kind of internal to the executive branch and internal to the president's team. Linda's written about this recently. And in different administrations, different groups within the executive branch seem to be the most influential ones in determining nominations. So to take it back a ways, the segregationists were a significant part of FDR's New Deal coalition. Had they controlled Supreme Court nominations, the Supreme Court in the 50s and 60s would have looked very different, but they didn't. They only got one person, Jimmy Burns, and he retired quickly, he resigned quickly. In the Eisenhower administration, it was controlled by people who were Republicans who were liberal on civil rights. And that makes a big difference. In the George W. Bush administration, it was Federalist Society types, and we got people who were movement conservatives and also very, very smart, very qualified. And they really wanted those people, and they killed, as much as anyone did, killed Harriet Miers. So I think the question really is not just what the president wants, and this bears on Trump too, but what the influential group, what the sort of internal executive branch dynamic is. And with the Democrats, it's very often what they call the groups. Minority groups, women, various other groups that they're the ones in there pitching for a nominee. So that I think President Clinton will come under pressure from those, and maybe she'll stand up to him and say, no, this is who I want, whether it's Merrick Garland or someone else. But there's going to be an internal executive branch dynamic that will decide this, and that's what we should be paying attention to.
David Savage.
I was going to ask you about a political scenario that I don't think you've discussed. Suppose Hillary Clinton wins narrowly, 46%, and the Republicans do well and keep a strong hold of the Senate. Do you think there's a possibility Mitch McConnell is going to say to Mrs. Clinton, when she gets ready to pick somebody who's fairly liberal, we're not going to go along with a liberal. We want an equal voice in this, and we're not going to go along with Mrs. Clinton's, President Clinton's liberal nominees. And in other words, could you see this stalemate going on for a while longer?
Does anyone want to bet against stalemate in Washington these days?
I don't want to bet against it at all, which is one of the reasons why I think it's quite likely she will renominate Merrick Garland, because there are a bunch of Republicans who are already kind of on the record as saying he's very qualified. We have no beef with him. It's just that the next president should pick the next justice. And
So he's the ideal nomination for her as well as for Barack Obama.
if she has a Republican control over the Senate, I would say she's not going to be able to get a really liberal nominee through unless it's a stealth liberal.
Right. So
she's not going to get somebody who on day one everybody leaps up on the left leaps up and says, "Oh my God, the rapture is here."
yeah, so I mean, if you think about past that one nomination, the Garland one for the next seat and the next seat, I think, if the Republicans hold the Senate, I do think that you're going to be in the world of a Democrat nominating people that, frankly, very few people have heard of, and who don't have the paper trails, and the like, and that that can be a very unfortunate thing for the court.
Lyle.
I've noticed for a couple of years that Justice Breyer seems to have very strong ambitions to emerge centrally on the court. And the two recent episodes have suggested that that's coming more out in the open. The central role that he played throughout the entire term on the Affordable Care Act birth control mandate in the Supreme case, in which I think he was very, very important. And then in the GG case, and the transgender case that just reached that, he gave the conservatives a courtesy vote in order to stay in the lower court decision. What do members of this panel think is his agenda? Is he really aiming to be the new O'Connor, Powell, Kennedy, or is he likely to be overcome by his inability to ask the question in less than
Well, I clerked for him, and I'm not just saying this out of loyalty. This is not a person. I think every justice has some ambitions and so on. I would never, and I don't think anyone who knows him would describe him as a particularly ambitious justice. I don't think he's sitting there and saying, "I'm calculating to be the center of the court" or anything like that. That's just not really who he is. I do think he has some strong views on the law, and they're pretty centrist and pragmatic. And I think he has, for the last few years, really had an opportunity to exercise those views. And so that started with, I think, recess appointments and him writing the unanimous opinion there. I think last term, there were a number of other examples as well. The idea that he gave a courtesy fifth didn't surprise me at all. That's exactly the kind of person he is. I don't think it's a calculating thing. I think it's just simply saying, look, this is going to be, an important issue. Some people feel strongly about it. I'll just, preserve the status quo. So, I don't, it doesn't strike me as something that is motivated by any sort of calculation or anything like that. Having said that, he's been on the court for 2 decades. He's now winning some stuff. I mean, last year he was the justice, the most in the majority, 94% of the time. So I think, that's got to be a nice, refreshing thing and be a reason why I think you could see him staying for a while.
Yeah, and I think in various cases, Lyle, we've seen, some combination of the Chief Justice, Justice Kennedy, and Justice Breyer kind of joining together, sort of the coalition of the pragmatic on the court. And I could see that continuing to some extent. On the other hand, I think Justice Breyer is going to have 5 votes for the direction in which he wants to go if Secretary Clinton wins the election. And so we may not see as much of that. And, of course, the misfortune for him in not getting the nomination that ultimately went to Justice Ginsburg is that Justice Ginsburg will have the assignment power in all of those cases.
Maybe one more question, Greg.
I'm wondering if the panel has seen signs of, or expects to see signs of caution on the court as a whole. We're going into this period of transition, both this term and maybe the next few terms with the 3 justices who are 78 or older. Would you anticipate whatever happens, we're going to see very incremental movement in the law?
We've already seen a couple of examples of caution that maybe have more to do with the 8-member court in some ways. The most obvious is the odd scheduling of the oral arguments this term, which is there are 3 cases that were granted last January, which were granted obviously when Justice Scalia was still voting, that haven't been scheduled for oral argument, even though there are a bunch of cases that were granted in June that have been. And at least a couple of those cases are pretty high-ticket cases. That is, you'd expect them to be high-salience cases. There's a religion case and a regulatory takings case in particular. We'll get a real indication in the short run when they come out of the summer conference if the grants are way down again. I mean, they barely seem able to fill the docket now. So there may be a whole bunch of issues that they just want to wait and take up at some later point, particularly if the justices don't have a big agenda on that issue that makes them want to decide it now because we might not have the votes later. I mean, that's, if anything, one of the lessons of Justice Scalia's death was there were a couple of cases where it was obvious that the court just waited a little too long to do its move. Friedrichs being the most obvious example of that, which is the court had public sector union agency fees in its sights for a bunch of terms, and they thought, well, we'll just chip away, and then after it's kind of, swaying from side to side, then we'll cut the legs out from under it, and 2 weeks after Justice Scalia died, didn't they affirm by an equally divided court? It was about 2 weeks later.
A different way of thinking about it might also be just if you think not just for the next term, but the next few terms. 3 of the 4 last nominees come out of the Solicitor General's office. I would say have a more cautious attitude about precedent and so on. Alito, the chief, and Justice Kagan. Just Sotomayor playing a very different game, I think, and much more willing, in a way, almost a liberal version of Justices Scalia and Thomas, to take a more aggressive view, less cautious. And which one of those wings kind of controls does really, I think the new nominees will have a big role there to play, and which side of the court they're going to be on.
Ken and David, some final thoughts on this?
I just think it's going to take a while for the court to reach the new normal, particularly if this is the beginning of an extended period of transition with additional retirements and new members coming onto the court. And just as an actuarial matter, it seems quite likely that we're entering such a period in the court's history. And if that's true, I do think it's going to take a little while for things to shake out. The justices have to get to know each other. And as has often been said, kind of regardless of judicial philosophies, any change in the court's membership has a profound effect on the institution. If we're going to have a significant change in the court's direction, that will be all the more true.
I agree that the court's likely to be cautious. I don't think I'd attribute it so much, at least not entirely, to change in membership. I think the liberals on the court, with the possible exception of Justice Sotomayor, I don't think they have a clear agenda. And I think that is a result partly of just temperament, just that sort of person. Partly it's the dynamics of the Democratic Party, where the Democratic Party's agenda, unlike the Republican Party's agenda over the last 10 or 20 years, has not really been court-focused. I mean, the Democrats care about health care, minimum wage, climate change, and those are not court issues. The court issues, for the most part, abortion is an exception, and there it is. There is an agenda. The Republican issues, guns, property rights, issues of business communities concerning, those are more court-centered. And partly it's because, the court has been a court dominated by conservatives for a very long time, at least dominated by Republican appointees for a very long time. So if you're a liberal, like someone like Justice Breyer, Justice Kagan, even Justice Ginsburg, what's the point of having an agenda? You're not going to get anywhere with it anyway. You're going to be on defense most of the time, maybe advancing a little bit here and there. And I think if you sort of look at, the Federalist Society had a pretty clear idea where they wanted to go. There isn't really anything comparable that's kind of captured the left. And one thing that is possible is that if we get a court with a Democratic majority, you'll see that starting to emerge, and we'll get a sense of what the liberal agenda is. But it's not there yet, and I think that as much as anything is what's going to cause the go slow.
That was terrific. Please join me in thanking this group. I'm on the ACS board.
It's a big issue for us. It's very interesting to try to figure out why. We'll see what this is.
All right, thank you.
I believe that